welcome back. We're ready to start back into the American jurisprudence on trust. And tonight we're going to be going over the types and purposes of trust. So let's get anyone else is in here, please hit the like so I know that everybody is getting the stream. Let's see how this is going here. It looks like it's broadcasting well. Tonight we'll also be using Black's Law Dictionary, 9th edition, for any of our definitions. Yeah, all right. So it looks like we're getting people filing back in here. Great. And definitely hit the notification bell so that you can always be sure to get the notifications. That bell's important. All right, let's get going. So, American Jurisprudence, working from the 2nd edition. And tonight we're going over Section 7, or starting with Section 7, and that's the definitions of trust, of particular types, or for particular purposes. Very straight up. The nice stuff, we have some forms in here, sprinkling trust forms and qualified personal residence trust. Nice little forms we got in here too. Model codes and restatements. So we're going to see this word, excuse me, codes, and we'll see this word restatements a lot. And it looks like a very simple word, but let's think about what a restatement is. Here's the restatement third, trust sections 26 referring to. So what I want to get at is, let's get this done properly and figure out what do we mean by a restatement. And the best way to do that is to go to Black's Law. Here, and let's get to here we go, restatement. Excellent. One of several influential treaties published by the American Law Institute describing the law in a given area and guiding its development. Influential treaties. So these are basically written instructions or guides for running businesses, I guess, in this case, because we're talking about the American Law Institute, describing the law in a given area and guiding its development of law by describing the law in a given area. Restatements used in a distinctive format of black letter rules and official comments, illustrations, and reporter's notes. Use a distinctive format of black letter rules, official comments, illustrations, and reporter's notes. Although restatements are frequently cited in cases and commentary, a restatement provision is not binding on a court unless it has been officially adopted as the law by that jurisdiction's highest court. Restatements have been published in the following areas of law: agency, conflict of laws, contracts, employment law, foreign relations law of the United States, judgments, law governing lawyers, property, restitution, security, suretyship, and guarantee, torts, trusts, that's what we're talking about tonight, and unfair competition, also termed restatement of the law. So, what is a restatement? If anyone has a clear idea from what we just read, good luck because we're going to read more. We speak of the work in which an organization should undertake as a restatement. Why didn't they just start with that, right? And this is coming from the report proposing the establishment of an American Law Institute. So we speak of the work which the organization should undertake as a restatement. Its object should not only be to help make certain much that is now uncertain and to simplify unnecessary complexities, but also to promote those changes which will tend better to adapt the laws to the needs of life. This is some deep stuff. So we're not talking about just a rule or a code or anything else. This is a restatement of the law. It's the work which an organization should undertake. Okay, and its object should not only be to help make certain much that is now uncertain, to make certain much that is now uncertain. Interesting. Make certain what is uncertain. And to simplify unnecessary complexities, not any complexity, but unnecessary complexities. And also, this is the best one, to promote those changes which will tend better to, and this is the natural law here, to adapt the laws to the needs of life. So this is a restatement, to adapt the laws to the needs of life. Now we understand the intention of a restatement of the law better than most would, just because of this simple phrase. Let's continue on this because this is some good wisdom. The character of the restatement, which we have in mind, can be best described by saying that it should be at once analytical, critical, and constructive. At once analytical, critical, and constructive. Beautiful. So, let's see here. Everybody else coming back in here. So we got Audit Them back in the house. Great. Glad everyone found the stream well. We get a few people here. This is going to be a very important stream tonight, so I hope more people file in. I want to get down to that because now you understand when we read these things as restatements. I want the audience here to understand that we're talking about something where it's a way for the laws to adapt to the needs of life, and a trust is guided by these restatements. This is the object of what we're trying to do with trust, to adapt our laws to the needs of life. And this is something that the laws have to be taken into account by intention at some point. Now, the nexus has to be established somewhere along the lines for the laws to have force over our trust. And that's what we're looking at right now, so that we understand the complexities, but be able to express it simply, just like these restatements do. Avoid the unnecessary complexity that you find that's very common with esquires, but that's not necessary. All right, let's continue. Let's see here. Okay. Here's the start. All right, definitions of the trust of particular kind. So forms, model codes, and restatements. Okay, there we go. So an accumulation trust is a trust whereby the trust interest or income is added to the principal or corpus so as to prevent expenditure of the interest or income. Accumulation trust, you get that? Where the trust interest is added to the principal. I don't know anything about taxes. I know nothing about law. I'm just trying to go over this stuff as basic educational, entertaining exploration into the foundations of American jurisprudence, and it's not meant for any kind of legal or lawful advice or practice use in any way, shape, or form. And do not try this at home. Let's continue. One of the distinctive devices by means of which individuals may combine their resources to operate a business for profit is the so called business trust, or Massachusetts trust, or common law trust, which may be comprehensively defined as an unincorporated business organization created by an instrument which by which property is to be held and managed by the trustees for the benefit and profit of such persons as may be or may become the holders of transferable certificates evidencing the beneficial interests in the trust estate. I don't think I need to go over this any deeper, but I think most people can understand that an unincorporated business organization that's created by this instrument, this trust, this business trust, Massachusetts trust, or common law trust. You hear this? Unincorporated business organization. Property is held and managed by trustees for the benefit and profit of such persons as may be or may become holders. So the beneficiaries may or may not be holders of transferable certificates evidencing the beneficial interests in the trust estate. Footnote 2. An illusory trust is one in which the settlor, remember the settlor is the one that controls the guidance of the trust, retains such control over the trust that is held to be a testamentary substitute, invalid, unless executed in accordance with the statute of wills. Footnote 3. A living trust is a trust which takes effect during the life of the settlor, as distinguished from a testamentary trust which is created upon the settlor's death. So we see here that the illusory trust only happens upon death, and a living trust takes effect during the life of the settlor. Remember, the settlor is the one controlling the trust. Of course, you can't control the trust if you're dead. A nominee trust is a trust in which the trustee holds legal title to the trust property for the trust's beneficiaries, but beneficiaries exercise the controlling powers, and the actions that the trustees may take on their own are very limited. That's a nominee trust. Such trusts are a common device for holding title to real estate and afford certain tax advantages. Let's read this one again. This kind of piqued my interest here. Let's see. We have more people here. I can't believe more people aren't here for this. Hit a 1 in the chat, or make sure you hit the like. This is ridiculous. We're coming up with some good stuff here. All right. I'm going to read this one more time. A nominee trust is a trust in which the trustee, person using the trust, right, holds legal title to the trust property for the trust's beneficiaries. One moment here. Numbers here. All right, let's get back to the meat of the matter here. A nominee trust is a trust in which the trustee holds legal title. Remember, there's an equitable title and a legal title. Legal title is enforceable in civil court, and the equitable title is in the court of equity, where it's enforced to the trust property. And remember, this is typically for real estate, right? Commonly for real estate. So the trust property for the trust's beneficiaries. So you're holding legal title for the beneficiaries, not equitable title, but the beneficiaries exercise controlling powers, and the actions that the trustees may take on their own are very limited. So such trusts are a common device for holding title to real estate and afford certain tax advantages. A nominee trust is not a trust in the strict classical sense because the trustee beneficiary relationship, or because of the trustee beneficiary relationship. Despite a nominee's trust's non traditional relationship between trustee and beneficiary, such a trust must still adhere to the rule that no trust exists when the same individual is the sole settlor, sole trustee, and sole beneficiary. Interesting line there. So we kind of went over that before, that you can't have the same person. This is the same individual. Okay, there we go. It's not person, but individual. A pour-over trust is a trust created with the intention that it be named as a beneficiary under a will, usually the grantors. Qualified personal residence trust is an estate planning device which permits the grantor to place a piece of real estate in trust, yet allows the grantor to retain a possessory interest in the property for a term of years. Qualified personal residence trust, estate planning. Grantor to place a piece of real estate in trust, yet allows a grantor to retain possessory interest in the property for a term of years. And what is a grantor exactly in the law is another. So we had a nominee trust. It's a trust in which the trustee holds legal title to the trust property for the trust beneficiaries, but the beneficiaries exercise the controlling powers, and the actions that the trustees may take on their own are very limited. And we learned that such trusts are a common device for holding title to real estate and afford certain tax advantages. A nominee trust is not a trust in the strict classical sense because of the trustee beneficiary relationship. Despite a nominee's trust's non traditional relationship between trustee and beneficiary, such a trust must still adhere to the rule that no trust exists when the same individual is the sole settlor, sole trustee, and sole beneficiary. So you can't be one individual that is every element of that trust. Also, remember that in the case of this nominee trust, the trustee holds legal title when normally it holds equitable title in a classical trust. So let's continue. A pour-over trust is a trust created with the intention that it will be named as beneficiary under a will, usually the grantors. And a qualified personal residence trust. So we were looking over grantors where we left off, and so rudely interrupted. So let's find. Okay, so there we go. One who conveys property to another, right? Settler. Right, settler. So what we want to do now, right, that was from the third edition. And we're looking at ninth tonight, so let's see what we have here. Different kinds of grantors, liens, grantor trust. Let's see, trust. That's interesting there. Okay, so a grantor is the one who conveys property to another. So remember, a conveyance is a transfer. Typo included, nice. All right, So we get this pretty well understood here, and of course, like I said, we could always get deeper and deeper into it, but I think that's all we really need to be for this purposes we have at this point. Grantor trust probably is going to be something else we'll get into later. Let's proceed. Okay, a qualified personal residence trust is an estate planning device which permits the grantor, when it conveys the property, to place a piece of real estate in trust, yet allows the grantor to retain possessory interest in the property for a term of years. The creation of a qualified personal residence trust results in three distinct interests in property. A possessory interest, or the right retained by the grantor to use the residence for a term of years. Two, a reversionary interest, which would be the value of the interest that could potentially come back to the grantor. Reversionary interest. Interesting. The value of the interest that could potentially come back. And three, the remainder interest which would pass to the eventual beneficiaries of the trust. So there are three distinct interests. Wow. Possessory interest, right, by the retained by the grantor for the term. Re- Reversionary interest, which would be the value of the interest that could potentially come back to the grantor, and the remainder interest, which would pass to the eventual beneficiaries of the trust. A revocable trust is a form of living trust that may be revoked by the grantor. A revocable trust is a unique type of transfer, as, by definition, when a settlor sets up a revocable trust, he or she has the right to recall the trust at any time and thereby regain absolute ownership of the trust property. Now, that's an interesting concept there, the revocable trust. Here, set up right. Great. Okay, if everyone's still there, make sure you hit the like and throw something in the chat and make sure I don't get knocked offline again. This retention of control over property distinguishes a revocable trust from other types of conveyances in which the principle of undue influence is applied. That is, gifts, deeds, wills, and contracts. Principle of undue influence. That's what distinguishes a revocable trust from things like gifts or deeds or wills or contracts, is that retention of control over property. A special needs trust is a trust designed to defray the costs of medical care that are not covered by any other public or private benefits program. A support trust is a trust created where the trustee is directed to use trust income or principal for the benefit of an individual, only to the extent necessary to support the individual. Support trust, huh? And remember, individual doesn't necessarily mean a man or woman. A Taunton trust is created when a bank deposit is made by a person, the holder, trust, right, of his or her own money in his or her own name as trustee for another. Taunton trust is essentially a device for the testamentary disposition of of an estate or portion of the estate. That looks like it needs some more looking into. A voting trust, as it's commonly understood, is a device whereby persons owning stock with voting powers divorce the voting rights, therefore, from the ownership, retaining the ownership to all intents and purposes, and transferring the voting rights to trustees. in whom the voting rights of all depositors in the trust are pooled. This is an interesting kind of trust that might it might be a little bit enlightening for further research, because you might find things like mutual funds and things like that that were used to dilute voting rights of depositors, uh, pooling them together. In this way, a voting trust could be used for social purposes, whereas if it's misused, it could be used to dilute the voice of the voting rights of depositors. Let's continue. Cumulative supplement cases. In a securitization trust, investors' relationship is with special purpose vehicle holding the trust assets, and their right to payment comes from cash generated by these assets, not from originator of the assets itself. That's from a 2011 ruling. Let's read that again. In a securitization trust, investors' relationship is with special purpose vehicle holding the trust assets, and their right to payment comes from cash generated by these assets, not from originator of the assets itself. Interesting one there. That takes a little bit more reading into. And here are lots of great footnotes for everything we just read. And the only one I see here, oh, look at this. Florida National Bank of Palm Beach County versus Geneva, Florida, 1984, as to the reservation of the power to revoke trust. Ooh, and as to exercise the power to revoke trust. In reference to the estate of Wyland, this is Illinois, 2003. Amended, appeal denied, 2003. Illinois, Missouri, Connecticut appealed. Okay, so a deposit by one person of his or her own money in his or her own name as trustee for another, standing alone, does not establish an irrevocable trust during the lifetime of the depositor, as it is tentatively trust merely revocable at will until the depositor dies or completes the gift in his or her lifetime. And that's 1995. Let's see. The presumptive validity of a voting trust under Maine law was established by a voting trust agreement, which plainly separated the voting rights of stock from the other attributes of ownership, was implemented for a specific duration, and was created assertively for the purpose of avoiding secret voting blocks and facilitating the transparency of corporate decision making. Kind of like what I was just describing here. It's 1999. Okay, let's move along here. Document, we're on to section 8. The definition of trust of particular types, or for particular purposes, and now we're looking specifically into land trusts. So if you guys are still there and still interested to keep going from here, please make sure you hit the like or hit a little something in the chat so I know that you're still along for the ride here. The stream has been a bit fickle tonight. Okay. In some jurisdictions, a land trust is a form of trust in which the beneficiary's interest is an interest in personal property and not an interest in real property. Interesting. In some jurisdictions. So this is interesting to look at in your jurisdiction, state, etc. A land trust is a form of trust in which the beneficiary's interest is an interest in personal property, not an interest in real property. In this type of land trust, both the legal and equitable title to the trust property lie with the trustee, while the duties, rights, and responsibilities tending upon real property owners continue to reside in the beneficiaries. Such a land trust thus differs from a conventional trust under which the trustee holds legal title, and the beneficiary holds equitable title. Interesting, that flip-flop there, didn't it? This type of land trust, by its very nature, is characteristically different from common law land trusts. Numerous authors have referred to the fictitious name of such trust. The Illinois Land Trust is a species of trust that, unlike other trusts, is immune to the doctrine of merger under most circumstances. Mergers of trust. So now we're getting a land trust, which is not real property. It's personal property. So we get into some pretty tight definitions here that we should look into too. As to the requirement separation of legal title, equitable ownership as basic to the creation of express trust generally. That's UCC, then as to merger, the meaning of legal equitable trust interest in one person as grounds for termination of an express trust. Ooh, that's Chrysler Credit versus Louis Joliet Bank and Trust, 1988. So a lot was going on. Remember the housing, or that was what was scandal was it? 88 involved all those trusts. Oh, there it is. A lot of legacy and case law. Now we're on to generally. Okay. Under the restatement, the following are not trusts. You ready? Successive legal estates, descendants estates, guardianships and conservatorships, receiverships and bankruptcy trusteeships, durable powers of attorney and other agencies, bailments and leases, corporations, partnerships, and other business associations, conditions and equitable charges, contracts to convey or certain contracts for the benefit of third parties, assignments or partial assignments of choses in action, relationship of debtors to creditors, mortgages, deeds of trust, pledges, liens, and other security arrangements. So, under this restatement, the following are not trusts. All right, let's continue. Agency. Agency is not a trust, as a fundamental difference exists between a trustee and an agent, and the distinction is chiefly in the character in which they act and the persons for whom they act. The term agency means a fiduciary relationship by which a party confides to another the management of some business to be transacted in the former's name or in his or her account. Still online here? Gosh. Here. Wow. Give me a moment here. Not one thing, it's another. More one way to skin a cat. Too far here. Everyone's still in here. See everyone in the chat. Are we still moving along? All right, we're on agency. Agency is not a trust. Okay, cool. All right. Just want to make sure I'm still broadcasting to the interwebs. All right, let's proceed. Agency is not a trust, as a fundamental difference exists between the trustee and the agent. Oops, yeah, we're off the screen here. Here we go. A little bit better. Now we should be maximizing our screen real estate. Excellent. Okay, let us proceed. Agency is not a trust. The term agency means a fiduciary relationship by which a party confides to another the management of some business to be transacted in the former's name or on his or her account, and by which such other assumes to do business and render an account of it. Render an account of it, an agent. In an agency relationship, the agent is the representative of the principal and acts for, in the place of, and instead of the principal. A trustee is not an agent of the trust estate or of the beneficiary, but acts for him or herself in the administration of the trust estate, although under the restraint of the terms of the trust and of the law of trust. In other words, a trust and an agency are distinguishable. Ready for this? Get your Esquire pen out for this one. They're distinguishable on the basis of the non-representative role of the trustee and the representative role of the agent. Got it? One has a representative role and one has a non-representative role. That's how you distinguish a trust from an agency. A trustee holds legal title over property, while an agent may hold legal title but usually does not hold any title at all. And while there is no pole star to guide one in the determination as to whether a given instrument creates a trust or the relationship of principal and agent, where there has been a transfer of title, it is usually held that a trust is created. So remember, a title is a written instrument. Hence, in a trust relation, the principal or donor parts entirely with control, possession, and right of disposition of the property involved, and the trustee acts in his or her own name, while an agent represents and acts for the principal. So get that distinction down there. It seems pretty clear. Trust, the principal and or donor, right, parts entirely with control, possession, and right of disposition of the property involved. And the trustee acts in his or her own name, right? We're still bound, by the terms of the trust and the laws. But the agent represents and acts for the principal. One of the prime elements of an agency relationship is the existence of some degree of control by the principal over the conduct and activities of the agent. In this regard, while an agent undertakes to act on behalf of the principal and subject to the principal's control, the trustee, as such, is not subject to the control of the beneficiary, except that the trustee is under a duty to deal with the trust property for his or her benefit in accordance with the terms of the trust and can be compelled by the beneficiary to perform his or her own duty. They can be compelled. Another interesting concept. The restatement second agency provides that a person who has title to property which the person agrees to hold for the benefit and subject to the control of another is an agent trustee and is subject to the rules of agency. To the control of another. See, this is the key. Other differences between an agency and a trust include the facts that ordinarily an agent may subject the principal to personal liabilities to third persons, while a trustee cannot subject the beneficiary to such liabilities. So the beneficiary is protected from liabilities through a trust. That an agency is created by the consent of the principal and the agent, while a trust may be created without the knowledge or consent of the beneficiary or of the trustee. And then agency can be terminated at the will of either the principal or the agent and is terminated by the death or incapacity of either. While a trust is ordinarily not terminable at the will of either the beneficiary or the trustee, or by the death of incapacity of either. So we have basically a trust not normally terminable at the will of either the beneficiary or by the death of either or their incapacity, whereas agency could be. So I think we beat that distinction down pretty well. Hope you're all taking notes. Let's continue. A bailment is not a trust. We're on bailment here. Sorry, I missed that one. There we go. Section 11, bailment. A bailment is not a trust. It is a characteristic of a bailment that the bailee has possession of property, and the title or ownership remains in the bailor, while in a trust relationship, legal title vests in the trustee and equitable title in the beneficiary or the trust. While every bailment is a form of trust, since a bailment involves the delivery of personal property by one person to another in trust for a specific purpose. The mere reposing of confidence in a party does not of itself create a trust or make a trustee of one in whom confidence has been reposed. And more than this is required to establish a fiduciary relationship of the sort which characterizes the creation of a trust. Furthermore, the subject matter of a bailment is always personal property, but a trust may be created in either real or personal property. Interesting there. And here we go. I love the observations. Delivery of a chattel to another with no writing may suffice either to pass title or merely to give possession. When an act is done for the benefit of the owner or a third person, or for the benefit of the bailee as well as for another, the potentially difficult question of whether a trust is a bailment is created depends on the intention manifested by the parties. Intention, again, is one of the things we need to focus on in jurisprudence and the manifestation is the actual trust here. So let's read this again. This is a delivery of chattel. So again, we're talking about bailments here, and a trust may be created in either real or personal property. So what is chattel? I think we need to look into Black's Law to find out what chattel is. Just get quicker doing it like this. Again, I really enjoy the paper ones a lot more. Having a nice book in front on the desk. In the meantime, if anyone's out there, if you could hit a little something in the chat, maybe hit a 1 just to stroke the YouTube algorithm and let them know that we're actually watching, and maybe bring some more people in to learn this important information. There we go. Come on. Almost there. We gotta jump a little bit more than that. So, anyone else out there still? All right, good. We have some chats coming in. That means there's people still there. So, scanned documents are terrible. But I need to have the whole document here. All right, glad y'all are still here. We're almost there. So chattel, too many contracts. Oh no, no, the stream. Okay, we're still there. I'm gonna search it next time. We're almost there. All right. Charging instrument. Okay, so chattel, almost there. There we go. Yes, sir. All right, I was buffering there for a second. Am I back? All right, here we go. Chattel, movable or transferable property, personal property, especially a physical object capable of manual delivery, and not the subject matter of real property. That money is not to be accounted goods or chattels, because it is not of itself valuable. Chattels are either personal or real. Personal may be so called in two respects. One, because they belong immediately to the person of a man, as a bow, horse, etc. The other, for that being anyway injuriously withheld from us, we have no means to recover them but personal actions. Chattels real are such as either appertain not immediately to the person, but to some other thing by way of dependency, as a box with charters of land, apples upon a tree, or a tree itself growing on the ground. Wow. Or else such are as issuing out of some immovable thing to a person, as a lease or rent for the term of years. So that's real chattels. And we're talking about chattel personal, a tangible good, or an intangible right, such as a patent, also termed personal chattel. And then chattel real is real property interest that is less than a freehold or fee, such as a leasehold estate. The most important chattel real is an estate for years in land, which is considered a chattel because it lacks the indefiniteness of time that's essential to real property. There we go. So that's what we were looking for. That basically the essential difference between real property and or real chattel or real property and personal chattel. Let's continue in this context again. So the delivery of chattel to another with no writing may suffice either to pass title or merely to give possession. When the act is done for the benefit of the owner or third person, or for the benefit of the bailee as well as for another, the potentially difficult question of whether a trust or a bailment is created depends on the intention manifested by the parties. So the intention of that no writing delivery of chattel. Deep stuff here. 12. Contract. So trusts are distinguishable from contracts in that the parties to a contract may decide to exchange promises, but a trust does not rest on the exchange of promises, and instead merely requires a trustor to transfer a beneficial interest in property to a trustee who, under the trust instrument, relevant statutes, and common law, holds that interest for the beneficiary. So, contracts in the parties to a contract may decide to exchange promises, but a trust does not rest on an exchange of promises. It requires on a trustor to transfer a beneficial interest in property to a trustee who, under the trust instrument, relevant statutes, and common law, holds that interest for the beneficiary. So it's not a contract. The undertaking between the settlor and trustee is not properly characterized as contractual and does not stem from the premise of mutual assent to an exchange of promises. So this is contractual elements. Although the trustee's duties may derive from the trust instrument, they initially stem from the special nature of relationship between trustee and beneficiary, and thus the trustee's undertakings or promises in a trust instrument are normally not contractual. Normally. A trust is also distinguishable from a contract in that a trust is a fiduciary relationship with respect to property. The relationship ordinarily created by a contract is that of promisor and promisee, obligor and obligee, or debtor and creditor. In most contracts of hire, a special confidence is reposed in each other by the parties. But more than that is required to establish a fiduciary relation. So there's special confidence reposed in each party, but it's required to have more than that to establish a fiduciary relationship with the duties assigned, right? An essential aspect of a trust is that the punitive trustee has received property under conditions that impose a fiduciary duty to the grantor or a third person. A mere contractual obligation, including a contractual promise to convey property, does not create a trust. One of the major distinctions between trust and contract is that in a trust, there is always a divided ownership of property. You get this? And that's why the first episode is called The Division of Title, because the title is the instrument of ownership of the property. And when you divide that ownership, you have to divide the title. The trustee having usually a legal title, and the beneficiary an equitable one. That's how we divide our title. Whereas in contract, this element of division of property interest is entirely lacking. A contract to create a trust is indistinguishable from a presently created trust, in that the former is merely a promise, while the latter is a fact. See, a contract to create a trust is distinguishable from a presently created trust, because one's a promise and the other is a fact. Big difference, isn't it? While the mere existence of a contractual relationship does not preclude the existence of a trust relationship between the parties of the same contract, a third-party beneficiary contract is not the equivalent of, or always, a trust. If property is transferred from one person to another who agrees to assume a personal liability to a third person, the resulting relationship is that of a third-party beneficiary contract, not that of a trust. However, a voluntary trust deed, under the terms of which the income of a trust property is to be paid to the settlers during their lives and upon the death of the survivor, with the principal to be divided among their sons, has been held to be a contract within the meaning of the contract clause of the federal Constitution. A voluntary trust deed, under the terms of which the income of the trust property is to be paid to the settlers during their lives and upon the death of the survivor, with the principal. So that was found to be a contract. Sucks for them in that. Contract law theory of no meeting of the minds. See this, the meeting of the minds in a contract to establish the primary elements. did not apply to a trust agreement between the settlor and trustee, whereas a trust agreement was not a bilateral agreement, but rather reflected the settlor's unilateral decision to place her assets into a revocable inter vivos between the people, almost as a gift, right? Trust to be administered by the trustee for the benefit of the settlor and her two daughters. So this is in the living, in between the living, given between people that are alive. Okay, see, as to the separation of legal and equitable estates. Interesting stuff all the way around here. All right, do we still have people in here? We're getting into debt, and I'd rather not stop on here. We could pick up from here next time. Still here? Yeah, still tacking away? All right. Try to see who else we have in the chat. All right. So we got people present. Let's continue with this. We're going to have to do more than just this, though. I can't end on just debt. All right. Debt is not a trust. Absent a contractual restriction under which a payment must be kept or used for the benefit of the payor, a debt, rather than a trust, is created by a payment. And the payor merely has a personal claim against the debtor. Interesting, huh? A trust is also distinguishable from a debt in that there is a fiduciary relation between a trustee and a beneficiary. Do you see this recurring theme? There's always a fiduciary relation. That's part of the intent of the trust, is to establish that relationship between a trustee and a beneficiary in a fiduciary manner. There's fiduciary duties, but not between a debtor and a creditor. That is, while a debt arises when one incurs merely an obligation to pay a certain sum of money, trust, on the other hand, exists where one takes on the duty to deal as a fiduciary with specific property for the benefit of another. If a creditor-debtor relationship, but not a fiduciary relationship, exists between the parties, there can exist no express trust. At times, whether a debt or a trust has risen may not be clear. In general, it is understood that when a trustee of the funds is entitled to use them as his or her own and commingle them with his or her own money, a debtor creditor relationship exists, not trust. So when the funds commingle, it becomes a debt. However, when one person delivers money to another for a specific purpose, the transaction becomes a trust when you deliver the money. Terms, however, that's the trust. And if there are terms within there, that could regulate as far as obligations. But a debt, that's why debt and trust may not be clear. Commingling is going to be, these are all going to be issues to consider. Is it a debt or is it a trust? And here we go. 1990, 1995. Oh, what did we read here? I'm sorry, trust. Okay, it's on this. As to the commingling by a trustee without authorization from the express or implied terms of the trust. Ah, see, there it is. Or trust funds or of trust funds or property with the trustee's own or other property and funds as a violation of the trustee's duty, rendering him or her liable for any loss therefrom. Rendering him or her liable. See that? Commingling. Loss. Commingling. We're denied for this is let's see, 1988. This one here is from 1990. Remember, there's that whole savings and loan thing that was going on in the late 1980s, early 1990s. Next one is executorship administration. This is an important one here now. So the restatement, third, trust. Again, remember these restatements, way to make the laws adapt to our lives. Personal representatives of descendants' estates are fiduciaries, but they are not trustees. Although many of the rules applicable to trustees are applicable to executors and administrators, and also to guardians and conservators, many other rules of trust law are not. Furthermore, an executor or administrator owes duties to estate creditors in addition to the general duties the fiduciary owes to the beneficiaries of the estate. There is also a difference between an executorship and a trust with regard to the property interests involved, as executors and administrators generally do not take title to the testator's real property. General rule is that the estate becomes vested on the death of the owner, or his or her heirs, or devisees, subject to the right of the personal representative, where authorized by the court, to use it to pay creditors in case the personal estate is insufficient to pay the debts of the estate and the expenses of the administration. Wow. So we're authorized by the court. So this seems the administrative aspects of it, and that goes, I guess, geez, take title to the testator's real property. General rule is the real estate becomes vested on the death of the owner in his or her heirs, subject to the right of the personal representative. In case they have different rights, I see. We're authorized by the court to use it to pay creditors. In the case the personal estate is insufficient to pay the debts of the estate and the expenses of administration. Furthermore, common law, the real property of an intestate descends to the heirs. And the representative has no power over it. A trustee, however, holds a legal interest in the trust property. Hang on, intestate. I've got to figure out what that word means. Never seen this word before, so I've got to find out what it means. Still looking here. Hang on. This thing had stupid headings on the pages. Almost there. Intestate. Jeez. Wow. Here we go. 26. Oh, I see what's wrong here. Let's switch guys over here. No, we didn't. There we go. Mike, fading in and out might have been me. Sorry. I think I get that fixed here. Intestable. Wait, what was the word we were looking at? Was, let's see the word here. Intestate. Real property of an intestate. Intestate. Okay. Let's see here. Intestate. Of or relating. Oh, really? Mouse clicks loud? Hang on a second. Let me see if I can fix this, guys. All right. Hang on a second. Give me a moment. Let's see if I can fix this real quick. All right. Check. A little bit better on that. Do the expander like this. Is that better? Check, check. Check, check. Check. 1, 2. Testing. Let me hear on my end, see if it's better. You shouldn't hear the mouse click now. Yeah, it's silent now. Cool. All right. So I'll talk here louder and hopefully everything's clear. Let's get back to where we were here. All right. There we go. Okay. Intestate. 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 Adjective. Of or relating to a person who has died without a valid will. Having revoked her will without making a new one, she was intestate when she died. Okay. Stream stalled for a second. You back yet? All right. I think we're back. Okay. Man, I have a lot of issues tonight. So check, check. Let's get back to this. So, the person who has died without a valid will. Is it better now? Does it sound better now? The sound. I was buffering really bad. It was the internet. Yeah, a lot of buffering. Hopefully, that's all it was. But I did make some sound adjustments, so perhaps it'll still be better now. Let me know if it does sound better, the audio. Looks like streaming's doing okay now. There, I can read it better. There we go. I can check it. All right, so of or relating to the property owned by a person who has died without a valid will. Intestate, right? So of or relating to intestacy. Archaic, not qualified to testify. Okay, so that's not what we're looking at. We're looking at of or relating to a person who has died without a valid will. Let's continue. Sounds good now? Great. So, furthermore, at common law, the real property of an intestate, someone that does not have a will, descends to the heirs, and the representative has no power over it. A trustee, however, holds a legal interest in the trust property, subject to the beneficial interest of the beneficiary. The intention to create a trust being a basic element necessary for the creation of an express trust, absent manifestations of such intention by the intention of the testator, which would be the intestate, I would assume. An executor retains a bequest in his or her capacity as executor rather than as trustee. So complicated stuff here. So let's get to the definitions. An executor is one nominated by a testator. Gosh. An executor is one nominated by a testator to carry out the directions in his or her will and dispose of his or her property according to the will after his or her decease. An administrator is one appointed by a court to administer an intestate estate. An intestate estate. So if you have an executor nominated by a testator, then you can have you won't have to have a court administrator appointed to administer an intestate estate. That's a tongue twister if I ever heard one. Yeah, make sure you wrote that one down. That's harder said than written. So now we go on to guardianship, conservatorship. This is going to be very brief because we don't cover that here. Even though a guardianship has been characterized as a trust relation, most of the sacred character, a guardianship is not a trust. See, it's been characterized as a trust relation of the most sacred character, guardianship. But a guardianship is not a trust. The offices of trustee and of guardian may be distinguished in that while a trustee has title to trust property, a guardian usually does not. A guardian ordinarily has only powers and duties respecting property to which the ward holds title. Similarly, conservatorships are not trusts. Long. Power. Section 16. Although a power is in the nature of or similar to a trust is distinguishable from a power in that a trust involves legal and equitable estates in different persons, while a power of appointment is not an estate or a property right, but is a mere right of power, a personal privilege, or authority. Trust is not a power. Trust involves a legal and equitable estates in different persons, while a power of appointment is not an estate or a property right, but is a mere right of power, personal privilege, or authority. So a trust is not power. In this regard, a power over property has been defined as a liberty or authority reserved by or limited to a person to dispose of real or personal property for his or her own benefit or for the benefit of others, and operating on an estate or interest vested either in him or herself in some other person. That liberty or authority, however, is not derived out of such a state or interest, but overreaches or supersedes it, either wholly or partially. Trust is always imperative in that it must be performed, although the trustee can be vested with discretion in various respects. While there is authority to the effect that some powers are imperative, ordinarily, the exercise of a power by a donee is purely discretionary or permissive and not imperative. Even so, in some instances, there may be a question as to whether a power of appointment is a mere power, discretionary in nature, or a power in trust, imperative in nature, and conferring a property interest upon the objects of the trust. The determinative factor in such instances said to be, again, which brings us back to the law, the donor's intention. That's what the law is going to enforce, is the intention. Right, so are we all still here? Bringing some more people in. I'm glad this is streaming. Furthermore, under some statutes, a trust authorizing a performance for a lawful purpose, but one not authorized for a trust by enumeration in the statute, is valid as a power in trust. Nice. It is possible for an instrument to create a power which is coupled with a trust, where a trustee is given power to appoint among a class. Such a trust with power of appointment among a class of beneficiaries has been said akin to the power of appointment coupled within the trust imposed. The power may be reserved to a trustor, as where a trustor reserves a power of revocation or modification. So, appointment among a class of beneficiary has been said to akin of a power of appointment coupled with the trust imposed. So, interesting things. So, express trusts are, which are sometimes referred to as direct, technical, or voluntary trusts. So we've heard of direct trusts, technical trusts, or trusts, are those trusts created by the manifest intention of the settlor to create them. Express trusts depend upon intention as distinguished from implied trusts, such as constructive or resulting trusts, which arise by operation of law or upon fraud or wrong, irrespective of the intention of the parties concerned. So that's an express trust depend upon intention, as distinguished from implied trust. So let's look at our definitions here. An express trust is created by the direct and willful acts of the parties. Some writing or deed or words expressly evidencing the intention to create a trust. While a resulting trust is one arising from a presumed intent of the parties at the time title is taken by one party under facts and circumstances showing that a beneficial interest in real or personal property is in another. Okay, and a constructive trust is a duty imposed by courts of equity to prevent the unjust enrichment of a holder of title to property which such holder acquired through fraud, breach of duty, or some other circumstance, making it inequitable for him or her to retain it. Now, this is an interesting concept right here, right? So, an express trust created by the direct and willful acts of the parties, with some writing or deed. So it's a written instrument or words expressly evidencing. So we need to have evidence that's going to be admissible in a court or in wherever we're having this heard, a court of equity, civil court. But this is looks like this is going to be in the court of equity, right? While a resulting trust is one arising from a presumed intent of the parties at the time title is taken by one party, under the facts and circumstances showing that a beneficial interest in real or personal property is in another. So it's presumed at the time title exchanges. So there again is another great concept there, and something worth considering. Again, intent is what we're looking at here. The intention of why trust was created in the first place is going to guide us is to figure out whether it's a express trust. So an express trust is created in one of two ways. Here we go. Take out your number 7 Esquire pencil. 1. A declaration of trust by which the owner of property declares that he or she holds it as a trustee for some beneficiary. So we want a declaration. Oh, the volume needs to be up. Let me see what I can do here. Darn it. Check, check. 1, 2. Give me a second. Help this a little bit. Check. 1, 2. Check. 1, 2. Testing, testing, testing. 1, 2. Is that better? Testing, testing. Okay. Testing, testing. Check. Great. Okay. We're good. Thank you for that. So I can make sure we're coming through clear. So here's an express trust is generally created in one of two ways. So we can create this express trust. One way is a declaration of trust. Get that? One, declaration of trust. And in this declaration, we declare owner of the property declares. What does that owner of the property declare to make this express trust? That he or she holds it as trustee for some beneficiary. I declare I'm holding this property for some beneficiary. That's your express trust, right? Or 2, a transfer in trust, by which the owner transfers to another as trustee or some beneficiary, either by deed or by other transfer, inter vivos between the people living, right? Or by will after death. So we have here a transfer in trust, by which the owner transfers to another as trustee for some beneficiary. Interesting there, huh? A transfer in trust. So this is a different kind of express trust. But the one that's been most familiar is just a simple declaration. So the owner declares that they're holding it as a trustee for the beneficiary, which gets the benefit of the property, right? All right, let's continue. Valid trust is not created merely by the creation of a moral, ethical, or honorary obligation or trust. An honorary trust is not a true trust, since an honorary trust does not conform to the time honored requirement that there be a beneficiary capable of enforcing the trust's terms. Once established and acknowledged, a trust does not need to be constantly reiterated or confessed. That's an observation. The Uniform Trust Code states the law relating to express trusts. I think we were looking into this last time. The Uniform Trust Code is probably more complicated than just the common law approach we're taking here, but it applies, so we have to consider it. So let's look at some of these footnotes where we could find something of interest here without having to look at the case text. An express trust is one in which the circumstances show that the grantor of the property intended to create a trust. Remember, we always want to focus on this intention when we're talking about trust. It's not the intention in and of itself, but that intention needs to be there. As to trusts arising by operation of the law. That's in Montana, 1997. Express trust is created by terms of will, deed, or other writing, or arising from direct and positive action of parties as evidenced by written instrument. 1995. This is as to methods of creating trusts. See section 18, which we'll be getting to probably not tonight. A trust in realty given by a mother to her son is not created by her statement of her desire that the proceeds of the property, if sold, shall go to designated persons. Ooh, 1957. Long-standing there. Trust in realty is not given by mother to her son, is not created just by her statement of her desire that the proceeds of the property, if sold, shall go to designated persons. Heavy stuff here. Right. And I think that's what we're getting here is to 18, creation of trust. And this is where we're going to be leaving off for tonight. We've had a lot of hiccups trying to keep this stream going, and I appreciate everybody for sticking around as long as they did, because this is really important information. I'm sure it'll be probably easier to rewatch, and I'll try to edit it and chop up the parts where we went offline and get this thing a little bit easier to watch. Let me get back over to the thumbnail here. So yes, we went over the trust types and purposes tonight, and that's going to definitely help everybody understand where these things apply and when they apply and for what purposes you would use a trust. And tonight we really went over the distinctions between agencies, debts, bails, and other things as opposed to trusts, and the main distinctions between each of them and the ones that make a trust stand out for what they are. Trusts are a very important historical instrument that's been used, as we see here, to align life with law and to allow a more less complex, more simple function of that purpose. And I think that we're starting to see that within this, what seems like a very simple concept and a simple word of trust, to be a very complex topic that actually, when you really distill it down to its intentions, is actually very simple. And I believe that something that anyone can understand, including anyone that feels like watching these, I believe will give us enough of an introduction for further discovery of how to take advantage of trust. So this is American Jurisprudence we're reading from, and it was, let me pull it up here, second edition. Hang on a second. Give me just a moment. Let me get back over here. So second edition, does it say it here? Okay, so 76 AmJur. Let me just put down here where we're leaving off. Excellent. So we covered some ground tonight for sure, and we got a lot of the background information out of the way, so that we got a good foundation of where we're moving to. And I think as this progresses, this particular episode here of trust, we're going to leave with something that's going to be actionable information that's going to be adds value to our life and should hopefully benefit us and posterity. And I hope that everybody continues to learn more about this and shares whatever they've discovered too along the way. As we've a little buffering, as we've seen in the previous episodes here, that we've come across things that actually open up more questions than answers. And I think that's one of the nicest things about working with American jurisprudence, because this is unique in the world to the United States of America, and it's probably our most treasured power that we have left, and it behooves us all to not only learn but to use it. So, with that, I want to thank everyone for coming, and I hope to see you all in the next one. Peace out.